Okay, we're on the record.
Fari Commission meeting Thursday, February 20th, 2025, 5 o'clock. Call to order, call attendance.
Okay, Brown, here. Hayes,
Me, I'm here.
yeah, I know, I have in alphabetical order.
Oh, okay.
Isley, we said resigned.
Yeah.
Lipinski. Matava,
Here.
Quinn, here. Okay, approval of the minutes, do I have a? So moved.
Second,
Seconded.
good. Anybody, all in favor of approving the minutes?
Aye.
Aye, good, that's approved. Old business,
Okay, there. Very
any old
good.
business we need to attend to?
I don't believe we do.
Oh, good. Well, we'll get right to the training.
The only
Are they
old
ready?
business would be to approve any changes or anything
But we're
that
gonna,
we talked about.
In the minutes?
Hmm?
It changes in what?
No, any of it from the last meeting, well, the last meeting we had in November,
That
those
was-
changes were added.
Changes to what?
We approved them online, though, didn't we?
Changes to what? What change? What are you talking about?
to the ordinance?
Okay, we'll talk about that after. I'm sorry. Okay, let's introduce, this is, so I have Rafi Podolsky and Sarah White here. And so I don't know, Rafi, I'm struggling with the view on our monitor on the screen. I have you both showing up on the little computer in front of me, but I can't figure out how to get it on the screen that we're all looking at. I just see Rafi, big picture of Rafi. But introducing over here, I think you can see everybody. This is Kevin Hayes is our chair. Deb Brown is a member. Scott Matava is a member. And Connie Quinn is our secretary. And that's everybody who's here. We've had one person resigned. One commissioner said they couldn't show up. So this is what we got. And I handed out to everybody copies, hard copies of the slides that Rafi sent earlier today, so I guess we're ready to go. I'm just gonna-
Okay, I'm a little concerned who you can see. Can you see Sarah or you cannot see Sarah?
Maybe when I speak, it might be in the view where whoever's speaking is on the screen. Is that what's happening?
happened.
Yeah.
Okay, so let's
Okay.
see.
So that's okay. Yeah, we can work with that. I want to, can I go ahead, Sarah, can I go ahead and start? I'd like to, I guess, I'd like to ask a question first before we get into this. I mean, well, Sarah and I need to introduce ourselves to you, but I actually want you to introduce yourself to us first. Could each of you just say something about what your connection is to the Fair Rent Commission, and if to what extent you have any, your landlord, your tenant, your homeowner? I mean, just something very brief about who you are. Would you mind going around the table and just kind of letting us know so we understand?
Not a problem. Kevin Hayes, chairperson, landlord, or housing provider.
Thank you.
That for 20 years, and I still have a small two-family.
Thank you.
I'm Deb Brown. I'm a retired attorney. And so I had some time, and so I'm working on this. In my past, I was a landlord about 30 years ago.
Okay,
That's it.
thanks.
Scott Matava, homeowner. I was born and raised in this town, 59 years now, so.
And Connie Quinn, homeowner, been living in this town about 25 years, but have not been able to be involved, and I wanted to do something to give back to the community,
Okay.
so I volunteered.
No, that's great. Thank you. Is there anybody on the commission who's actually a tenant or not?
She resigned.
Yeah, we did have one person who was a tenant, and but she's the person who resigned.
Okay. So let me just tell you something about who I am, and then Sarah can speak about herself. I'm a lawyer, currently with Connecticut Legal Services, but I've worked for the legal aid programs for many years. And I have had a long time interest in fair rent commissions, including, I live in Hartford. And back in the 1980s, I was a member of Hartford Fair Rent Commission, and I even wrote a little pamphlet on how complainants can file a complaint with the Hartford Fair Rent Commission. So I've had some experience, even though it's long ago and out of date. I've had some experience with actually participating in Fair Rent Commission meetings and discussions. And I'm very interested in the way they operate. Sarah and I were involved in putting together something that we called a toolkit. And I'm wondering if you have ever received a copy of that. It was an effort to kind of do
Yeah.
a question and answer.
We
Yes.
reference that often.
Yes,
Okay, all right, because that was our effort, at least at the time, sort of to answer as many questions as we could think of. And Sarah and I both come to this from the perspective of people who believe in the Fair Rent Commission, who believe that you have pretty extensive authority and that it's your choice what authority to use, but that you should shy away from the argument that you don't have power to do something, because the odds are reasonably high that you do have power to do something, even if you choose not to. And that's ultimately your choice. So that's me, Sarah. But let's turn it over to Sarah now.
My name is Sarah White. I'm an attorney at the Connecticut Fair Housing Center. I've been there for about 12 years. My 6-year-old is sitting with me because not feeling well. But like Rafi, I have not served on the Fair Rent Commission, but I got involved in sort of the revival of Fair Rent Commissions beginning in 2022. We surveyed everything that was out there, how commissions were functioning, developed the model ordinance, have been working with a bunch of different towns across the state to establish or revive Fair Rent Commissions, because many of them had become dormant over the years, since we had about 10 years of, flat rent increases. And have also been working with Rafi to support the development of a Fair Rent Commission network so that the commissions can be connected to each other, and we can have, a lot of support for commissions to, hopefully thrive now and in the future. And I'm just really happy to be here with you all. I did go through and look at your minutes. I've seen that you've done quite a few hearings, which is great. So the way we run these is we do a very basic PowerPoint, which will probably be, review, but sort of also offering our perspective on the role of Fair Rent Commissions based, on their history and their function, as well as the factors under the state law to consider. And then we just do a question and answer. So whatever issues you're running into, we're here to offer, our perspective as attorneys who at this point have probably worked with, I don't know, dozens of Fair Rent Commissions at this point. Towns do have a lot of flexibility with how to run them, but we can share what we've seen that seem to be like the emerging best practices for how to do it. Rafi, do you have anything to add before I get started with the slideshow?
No, I don't think so. I think you've sort of hit everything on that. So go ahead. I want to say, I think my computer keeps coming in with these virus symptoms that when it always manages to beep when it does that. So I'm going to try and turn my audio off when I'm not speaking, in the hope that you won't be able to hear all these tinglings that keep happening that I can hear.
And I just need a second because I have too many files open. So I have to close some files to be able to share slides.
Yeah, and is the share file thing is something that you do on your end, Sarah? Because I don't know.
I
how
can
to
do it on mine. Yeah, I have a PowerPoint.
Good,
Hang on.
good.
I just had too many things open. Let me see if it'll let me do it now.
What's your daughter's name?
This is Azad. Okay. And my cat's here too. It's just how it is. One of those days. Okay. And Rafi and I'll just kind of go back and forth on these. So Fair Rent Commission basics. So Fair Rent Commissions have been authorized for more than 50 years in Connecticut cities and towns, but weren't actually required until the law that passed in 2022. And at their core—
Are you thinking we should be seeing your screen now?
Yes. Are you not
'Cause
able
we're-
to see it?
No, we're not seeing your screen. So I'm
Okay.
wondering, I have host tools. Do I need to?
It says I'm screen sharing. I'm wondering,
And it
Hmm.
does say here, I do, share screen is checked here,
let
so I
me
don't know.
stop it and try again and see if that works. Okay.
And I just had my IT guy here. Well, in the meantime, though, I did print out the slides, so everybody has paper copies of the slides.
We could also just go through those. It's the same thing, so that will work just fine.
Hmm.
So I was just on the first one, what are fair rent commissions? And they are municipal boards with the power to limit or modify rent increases, but also rental charges in general, which are really broadly defined to include fees as well. So as to prevent them from being so excessive that they're harsh and unconscionable. And I know that language sounds very antiquated. That's because it's from 1969, but that is the standard in the state law. And the role you have as a fair rent commission is just incredibly important because most tenants have no practical way without a fair rent commission to challenge an unfair rent increase. No matter how egregious, even if it's doubling rent, if there's not a fair rent commission, the tenant may be out of luck, or in some circumstances, they may, in theory, be able to go to court, which of course is very challenging for tenants who typically do not have access to an attorney. And the idea of the Fair Rent Commission is really that you all are the conscience of the community regarding rental charges and increases, that your community better than anyone else, have like a shared or can get to a shared understanding of what is fair, what is improper, and you're supposed to be ordinary residents of the town, not like experts. Rafi, do you want to do the next one? Oh, you're muted, Rafi.
All right, maybe I should just leave the mic on. I want to add one thing to that. And we'll come back to this in a minute, but your basic standard is what in the statute is referred to as a rental charge, not a rental increase, but a rental charge being so excessive as to be harsh and unconscionable. But there's also a second standard that says rent can be reset to amount that's fair and equitable. And there are some circumstances, which we'll come back to, where you might go directly to the fair and equitable standard. It's not clear that those two standards are actually different from each other. In any event, moving to page 2, the Fair Rent Commissions, because of the way in which the Fair Rent Commission Act is structured, that what you're really doing is you're looking at the disconnect between the rental charge, of which the main part of the charge would be the rent, and the product that the tenant is receiving. And that's what you're saying is that so excessive as to be harsh and unconscionable. And because of that, you're not really talking all the time. Most complaints you get are going to be about rent increases. You may also get complaints about service decreases. The most obvious circumstance being if something that the landlord used to pay for is now going to be transferred over to the tenant. But one of the things the tenant is paying for is reasonable maintenance. And every landlord is supposed to comply with code requirements. And so sometimes what the tenant's not getting may be, for example, compliance with the housing code after the Torrington enforcement entity has ordered the landlord to make certain kinds of repairs. So what might have been a perfectly reasonable rental charge becomes unreasonable because, for example, failure to comply with a housing code order. So one of the things that the commission functions to do is to buttress housing code enforcement. And you have a number of options, one of which might be to reduce or hold back a rent increase or all or part of a rent increase until there's code compliance, which then addresses both the rental charge aspect, but also that gap between what the charge is and what's being provided. The second thing that's really important is that lots of disagreements among landlords and tenants come because they don't talk to each other. And a rent increase may trigger that conflict. And you may get complaints when there's never been any conversation between the landlord and tenant. Tenants don't realize they can bargain over the size of a rent increase. So one of the functions of a fair rent commission is that function of what I would call voluntary conciliation. And typically that would go through a staff person, not through the commission itself, where a lot of fair rent commission complaints get resolved and never get to the hearing stage at a fair rent commission, because once you get a third person in, it helps the parties communicate with each other. And sometimes it turns out that there is something that actually can be agreed upon, and everybody can kind of feel like they've gotten what they wanted. All right, Sarah.
I just wanted to say, yeah, one thing about buttressing housing code enforcement, this is really important and powerful when you have those situations where a landlord, for whatever reason, maybe because of their business model, is really dragging their feet on making repairs that are necessary for health and safety. The town's options in those situations are, a citation with a fine or a referral for criminal prosecution, but those take a really long time and often are really not enough of an incentive to get, more of a bad actor landlord to make repairs that are unsafe. A fair rent commission, choosing to suspend rent or reduce rent until repairs are made, can more directly often incentivize the landlord to finally get things fixed. So that is a really important role that you play, in conjunction with health code enforcement.
Moving on to page 3, that's still you.
All right. So what are fair rent commissions for? So the idea of fair rent commissions going back to 1969 is to provide sort of individualized rent stabilization to tenants who already live in an apartment, like recognizing that, the social and, often financial costs of, pricing people out, forcing people to move, can disrupt kids' education, can, affect families' well-being and health, can move people out of a community where they may have deep ties. So it's this sort of individualized rent stabilization only for people who already live in an apartment. So it doesn't reach, what rents a landlord is, maybe charging on Zillow or something like that, based on a tenant complaint about, like we talked about, unfair rent increases, bad conditions or reduction in services. Often we see like infestations, mold, maybe a broken elevator, and then also landlord retaliation, both for a tenant going to the Fair Rent Commission and for, other things the tenant may have done to assert their rights to, safe housing. And under state law, any tenant can complain unless they live in a seasonal rental, which is like truly a short-term rental. It's not month to month. And then the general process, as you all know, is the tenant complains, there's informal conciliation, possibly investigation, a hearing, and then a decision. Rafi, did you have anything you wanted to add?
No.
All right. Do you want to do the next one?
So Fair Rent Commission, I mean, you've already had experience with some of this.
So
So
excuse me, Rafe, we were muted, but can people ask questions as we go along, or do you want it to wait till the end?
I don't know if Sarah and agree on. I'm inclined to say, why don't you ask questions as we go along?
Sure.
I don't want to get boring. So
Yeah.
just go ahead and stop us if you got questions so far.
Good.
Okay, my question is, it's for people who live in apartments. So if I'm a tenant renting a house, that I don't qualify for this? You're saying that the stabilization is only for people in
No.
apartments?
Any kind of rental. The only
No.
thing that is like excluded is like an Airbnb type situation, or if you, rented a summer house.
Okay.
But any type of rental, house, apartment.
And it's also important to note that mobile home parks are explicitly included in the statute. And typically in a mobile home park, most of the time, not all the time, but most of the time, the person owns their home, but they rent the land, and those are covered. So in other words, their complaint would be about the land rent rising, rather because they're not paying rent
So
for
I
the
think
home.
just a suggestion then, Sarah and Rafi, is I think what Connie is focusing on, she's takes things very literally. And your third slide says rent stabilization to tenants who already live in an apartment. So she's reading that thinking, oh, is it only people who live in apartments?
No, our
So-
miswording.
Yeah.
It's, doesn't
So just-
matter, doesn't matter.
Okay, Rich?
So should we keep going?
Yeah,
Okay, so what we've seen the kind of decisions that fair rent commissions tend to make are typically not all or nothing decisions. They sometimes are. I mean, an all or nothing decision would be the rent increase is perfectly reasonable and therefore the tenant loses. That would be an all or nothing decision. Or the rent increase is really totally unjustified and the decision is going to be to leave the rent as is, or actually maybe in some circumstances even to lower the rent. Those would be sort of total decisions going for one side or another. But sometimes, and probably most of the time, the commission may come up with something in between, especially since what's being usually put in front of you is an increase. So you see decisions where the commission agrees that an increase is appropriate, but not in the dollar amount that the landlord is asking for. Or sometimes you might see a decision that says that the rent can be raised either partly or totally to what the landlord is asking for, but not all at once, and it becomes sort of a phased-in order. Sometimes you'll see a decision where the order is conditioned on something. Again, all these can be combined together. You can put a condition on and also impose a restriction on the amount of the rent. Code violations are one kind of a restriction that I think is fairly common. Until they're fixed, you can't get an increase or whatever amount the commission has said was okay to get. It could be something besides a code violation. Sometimes you may have service and maintenance complaints that aren't really about code. I've given people the example of an elevator that doesn't work in a multi-story building, but it's not high enough tall enough a building that it's under any state regulation that you have to have a functioning elevator. But on the other hand, when the tenant rented the apartment, there was supposed to be a functioning elevator in the building, and the landlord has resisted fixing it. So that might influence how you would approach something. So those are types of things where the commission can be creative in what it figures out as the reasonable order. You have the powers to stop retaliatory conduct. Most of the retaliatory complaints that you would get would be essentially retaliation because of the fact that a tenant filed a complaint. But you may have other kinds of retaliation as well, and the statute allows you to address retaliation issues. Am I leaving out? I wasn't looking at the
No, I mean, I
text.
think
Did I leave
just
anything
to
out?
emphasize what Rafi said, you really can be creative to figure out what works for this situation. Like you have broad power and, that could be a very flexible decision. You could also ask if there's a conditions problem, ask the parties to come back after a certain amount of time to report back on, progress and correcting things. I'm sure there's all sorts of things like, fair rent commissions haven't even come up with that you could do to address certain situations. So don't feel like you're hemmed in by having to just, go with either side or, do an order that just, allows a certain amount of rent increase. You can phase it in, you can do all sorts of different things.
I want to add a couple of things. I'm not sure if I'm going out of order in terms of our pages on the PowerPoint, but part of you can also control the length of your decision. In trying to come up with a model lease, a model ordinance, and I don't remember what's in your ordinance, but our suggestion was that commission decisions should generally last for a year, unless there's some reason to make them for some other length of time. A phased-in rent increase might go on for more than a year. There might be circumstances where you would go less than a year, but I think the general assumption is you're matching it to the time of a common lease, which is a year. And I mean, I've had it argued to me that, well, if the tenant's on a month-to-month rental arrangement, then your decision should be only good for a month, and that makes no sense. That I mean, the commission, the statute anticipates that you're going to make a decision that's going to last for a length of time. So that becomes, again, part of what the commission can do. It's going to determine, it can determine, how long. The other thing I wanted to mention is that you also have the power, and it's something that's explicit in the state statute about escrowing rents. Our experience is that commissions do not want to escrow rents, and I think that's the correct gut reaction to have, because it turns you into kind of a rent collector. And it requires some real monitoring from your end, from a staffing perspective. The statute says if your order suspends the collection of rent, then the tenant is supposed to be paying rent into an escrow account that's supervised by the commission. We have read that to mean, and I think most commissions read that to mean, that if you bring the rent down to zero, that's to say to suspend the rent. If what you do is order a reduction in the rent pending certain things happen, I think maybe this is parsing the statute very carefully, but we believe you don't have to escrow rents under those circumstances, and most commissions would not, just because it's a troubling thing to do. So, for example, I know that there are cases in New Haven, for example, actually in Shelton, I know of a case where because of landlord resistance to compliance with basic housing code orders, they brought the rent down to $1 until such time as the repairs were made. This is somebody who refused to comply with orders. In a sense, it's a failure of the incentivization system, but I don't think they were escrowing any rent payments. And in any event, even if they did, they would only be escrowing $1. But I think they chose $1 rather than zero because they did not want to have to be doing escrows. So I
New
mentioned
Haven
that to
and
you.
Hampton have also done that. So that is been done by quite a few commissions at this point.
So yeah, so that's something you should know in terms of, again, this is really, I'm addressing the variety of the kinds of decisions that you can come up with. Okay, I'm done with my page.
Rafi,
Sarah.
do you want to start on the factors?
Sure. Okay. The statute, this takes us back to the fact that you have discretion, and the statute lists 13 factors that must be considered if they're applicable. So they're not necessarily all applicable in any case, and to some extent, the parties may control which of these factors are applicable. But typically, you're going to find out, and I mean, again, you've held hearings, so you know this already. Typically, different cases are going to have different factors that are important, and in some cases, there really only may only really be one or two factors that are going to make a difference to you. So we in the PowerPoint, we've tried to group them. The fact that there are 13 factors, statutory factors, again, with a certain amount of quaintness when you talk about counting the number of toilets, from the way people were looking at housing codes in 1969. But the way we've grouped them in that to us reflects the importance. Number one, the size of the increase, the dollar amount, or possibly the percentage amount, and the history. To what extent is this a big increase coming after small increases, a small increase coming after big increases? All of that may be relevant to you. Second was, are there any things the tenant has to pay for that it's not covered by the rent? Who pays for the heat and utilities? That's going to make a difference to you in terms of assessing situation. And sometimes we see situations where there's actually a rent decrease simultaneously, say, with transferring the electricity from the landlord's account to the tenant's account. Well, that may actually turn out to be literally an increase because the landlord was paying for electricity before. Now the tenant's paying for it, but the rent reduction is less than what the typical tenant bill would expect it to be. So those questions, I mean, that's a category of things that you're thinking about. What's included in the rent, what's not included in the rent. Another one is what's the condition of the apartment, both in terms of amenities and in terms of quality of maintenance. That would include things like violations of the housing code, but it also includes differences in sort of just the normal things that are provided as part of the leasing arrangement. And in some cases, there may be, extra kinds of things that are beneficial to the tenant. There may be a swimming pool in an apartment complex that most tenants wouldn't have. I mean, so there are things, again, all of these things can cut one way or can cut both ways. It's not that any always goes in favor of either the landlord and tenant. The next one on our list is the landlord's operating costs. These are obviously important. That how much is it costing the landlord to run the building? To what extent have the landlord's expenses gone up or down? And again, these things, taxes can go down as well as going up. My advice to commissions is be careful to distinguish between what are actual costs and what are sort of theoretical breaks, like depreciation is not really a cost of running a building. So I would tend not to give any weight to depreciation, but paying interest on your mortgage, that's a real cost. That's an out-of-pocket cost for the landlord. Next category is tenant's income and the availability of alternative housing. So one of the factors may be the tenant cannot afford the apartment, but that's only one of the 13 factors. But you can take into consideration the impact on the tenant's ability, the ability to afford the payment, and what often comes with it is the ability of the tenant to move and find another place. When tenants' income is low, it's often very difficult for them to move because if they can't afford where they are, they probably can't afford any place else either. But that's not the only factor to be considered. My feeling is the larger the building or the complex, the more this factor plays a role with the commission, because it's easier and more, in terms of running a building, easier for the landlord to make an accommodation for a particular tenant when they've got a lot of other rents coming in than it would be, say, in a two-family house, where it's much more difficult for the landlord to accommodate. And the last of the groupings, I guess we have 6 groupings, are comparable rents in the neighborhood and in the town. But comparable rents are very, very tricky. And I will give you a warning on this. That first of all, they're only one of the 13 factors. So there's no such thing in a fair rent commission that somebody has a right in a sub-market rent to immediately start charging the market rent, or necessarily even ever charging the market rent. It's a factor, and it's definitely a factor that's very legitimate to consider. But the other difficulty
Rafi,
is,
I just have one question. When we were
Sure.
having a hearing, we were trying to figure out that they have to bring that in as evidence, the rents. We don't look it up ourselves, right?
no, our view is that nobody has to bring anything in. But you're not going to be able to consider it unless somebody brings it in. So for example, if someone wants to argue comparable rents, they're going to need to come in and tell you something about what the comparable rents are. This can be done either on a formal or informal basis. I mean, it could be done by bringing in a professional who's going to talk to you about, what what market rents are, or it could be somebody brings in their neighbor and says, this is what I'm being charged for rent, and this is what my apartment is like. One of the reasons
Oh, go ahead.
comparables are so difficult in the rental market is because it is so hard to determine what is comparability. For example, let's say the landlord's not doing very much maintenance. Well, then that means a comparable either has to be an apartment, say, in a different building where the landlord's not doing much maintenance, or you have to modify, do an adjustment based on the difference. But in order to get the comparable, you don't really know what kind of maintenance the landlord's doing. Comparable would be these are by definition, the tenants who complain to you are tenants who are in place. Let's say they live there. If they don't live there, they can't file a complaint. So they're dealing with typically either a change in the rent or the changes of the circumstances there. Typically, property owners charge more rent to new renters than they would to a renter who's in place. So when you're looking at comparables, are you looking at what the asking prices are for new renters, Or are you looking what other landlords are charging for people, say, who've been living there for 5 years? It's a significant, because fair rent commissions are all about rent levels, that becomes a significant issue in doing comparables. So there are lots of other issues of that as well, but all I'm saying is it's a reason why you need to be cautious about comparables. There are some commissions who've raised the question, well, Section 8 puts out fair market rents. Does that mean any landlord is free to raise the rent up to the Section 8 fair market rent level? That may be useful evidence towards the question of what are comparable rents, but you've got 12 other factors to think about. It may be way too big an increase to get to that amount if this is a sub-market rent. It may be that in lots of ways, this particular unit is different. Section 8 fair market rents assume full code compliance. I mean, so there may, at most, it's a factor, and it may turn out in some cases it's a highly important factor, because what you're doing is you're doing the weighing process. How much weight do we give to this factor? How much weight to another? And that may vary from case to case. The other thing is the statute lists 13 factors, but it doesn't prohibit the consideration of other factors. And so we've always said if a factor is relevant, then you can consider it, even though it's not on the list of 13. And I'll give you an example of that I know came up in Clinton. It came out of a complaint from a mobile home park. Clinton doesn't have a lot of mobile home parks. And you're talking there about ground rents and not about the rent for the building. And the statute refers to rents that are comparable, with the comparability in the town, in the neighborhood, in the town. That's what the statute lists as one of the factors. Well, there really weren't any comparables in the town because there wasn't a comparable choice in mobile home parks. But if you went across the town line into the next town over, there were similar mobile home parks. You can't interpret the statute as saying we can't go and look at the rent across the line, even though it's obviously relevant to our decision, just because it wasn't one of the 13 on the list. And I just give that as an example. There could be lots of other things that are not on the list. And
Can I add one thing? I was just going to add for the comparable rents question, in addition to what everything Rafi said, that it's comparable rents for that apartment, for an in-place apartment, that tenant in that neighborhood, in that condition. There is also no perfect data set out there of rent. So depending on which, data set somebody looks at, it may come up with like wildly different rent figures. So that's just something to like watch out for. Zillow has a data set, apartments.com has data, HUD, does a survey, but none of them, like nowhere aggregates like all of the rents in a town or city, because many still are not done through these platforms. And there are different sub-markets in housing, different neighborhoods, different landlords offering different products to different, income levels. So that's just another thing to watch out for, if someone's bringing you comparable rents and using that as a basis for a large increase.
But I guess I want to mention one other thing as well. What was I going to mention? This is going back to your original question about do we have to go out? Are we supposed to go out and find our own information? I mean, the answer really is no, because the city staff town staff can get information for you if you want. So, for example, the housing code issues. What a lot of commissions will do is, if the complainant includes the condition of the premises as one of the reasons for the complaint, the commission will ask the code enforcement agency to go out and look at the place and come back with a report. And you want that report back in time so that you'll have it when you meet on the case. And so there, the commission is in fact getting its own information, but not you as the commissioner. Rather, the staff is producing that for you. The other thing is, if people don't want to present information on something that they're allowed to, at least my experience in Hartford when I was on the commission was we had the power to subpoena the information. And certain kinds of information you may ask for as a matter of routine as part of an application. But if people don't want to give it to you, my belief was, rather than subpoenaing it, you just say that party is effectively conceding that argument. So, for example, if the landlord says, I've raised the rent because I've got all these new costs I have to cover, well, then give me an operating statement that shows that shows that. If they say your operating statement's not, my operating statement's none of your business, okay, but then we'll just assume for our purposes that that's not a reason, but you don't lose the case automatically because there are other factors. Or the flip side is if the tenant says I can't afford it, but refuses to give you any information about their income sources, you could subpoena and say, I want these records, or you could say, we're just going to assume that affordability is not the key matter for you because you're not giving us any evidence from which we can draw a conclusion. But you might say a big rent increase is unreasonable at this time, no matter what what your income is. So it doesn't guarantee, because it's only one of the factors. It doesn't guarantee that a party is going to lose because they won't give you information if, in your ultimate judgment, the other factors play a sufficient role that essentially it overrides the fact that you don't have information on something. I think it's not. I think
Raise your hand.
I think
Give 'em away.
I think it's common that commissions ask for operating statements from landlords, but I don't know if they all do. I'm sorry, somebody had.
Yeah, based on income, and they come in and say they can't afford it. Is there any type of guidelines to use? What is a reasonable amount of income to the rent?
Well,
There's nothing that a Fair Rent Commission has to follow, but there's sort of a shared assumption that 30% of someone's income for housing costs, so that's rent plus utilities, is considered affordable. Now, with everything else going up, that was, I think, developed maybe in the 1960s. Does that sound right, Rafi? So, but that's not something you have to follow, but
Well, the banking industry has 28% of your income going to housing.
well, there's actually a state statute on this. It's 8-39A is the statutory number. And it says that for households that are below the area median, below 100% of area median, affordable housing is housing for which they pay less than 30% of their income. So it uses the 30% figure. You have to include heat and utilities in that figure. So if the tenant is paying their own heat and utilities, you got to cut. It's the rent plus the heat and utilities if they're not included in the rent. But there's no statutory right that you have a right not to pay any more than 30% of your income. And in terms of the Fair Rent Commission, it's, you could use that as sort of a guideline towards affordability. But again, it's really not that explicit in the Fair Rent Commission statute. And it's not, just like any of the other factors, it's not decisive. It's a factor to consider. And as I said, it tends to weigh more heavily in some circumstances than it would in others. But when there's one or two really dominant factors, very large rent increase being the most obvious one, that I think commissions are likely to come to pretty much the same decision regardless of the income of an individual tenant, because the increase itself seems to be so excessive as to be harsh and unconscionable. So it can cut many ways, and that's part of your job. That's part of what makes it hard to be a commissioner, in my opinion. Sarah, why don't
I think the next two slides we had were about the process of a complaint and what hearings look like. But since you all have already done hearings and heard complaints, I don't know that we need to go over that. Let me know if anyone thinks differently. But then what we were going to kind of end on before we just sort of have a more open discussion with questions and conversation is a list of the towns that have Fair Rent Commissions. Rafi, do you want to do this?
Sure.
Oh, go ahead. Sorry,
I
what's
have
your
a
question?
question on the hearings, the example. We had talked about this, about interpretation is provided to anyone with limited English proficiency. So is that required or not? Because we were discussing it, but then we didn't know if the town would pay for it or how it gets paid.
So I'll just
Yeah.
chime in and tell Deb. So my view in our statute did, initially what I was proposing in our regulation was have an interpreter there with whoever needed it, pay for it. And Rafi pointed out, he didn't think that was a good idea. The town should pay for it. And what I'd say is the problem that we have is this is a relatively new commission, even though the statute came in 2023, this commission was not really populated until 2024. I was a relatively new corporation counsel and it's just me. You know, I'm the only lawyer in the city that the city has. I don't have a legal assistant. I don't have paralegal. So I did though convince the mayor that submitting a budget for the corporation counsel's office this year, I included line items for the Fair Rent Commission because there was nothing in the budget previous for the Fair Rent Commission. And I included supplies, postage, and an interpreter. And I think what I would do is rely on, so anyway, so when I redo the regulations and have our ordinance subcommittee review it, we'll delete the part that says the party has to provide the interpreter and will provide the interpreter. My experience as I was probate judge here for 24 years, and I know there are several services that probate administration hands out to the courts, like a list of ones that you do over the telephone. And in the probate court, we found them to be very good and very affordable. So anyway, going forward, to answer that, I think that's what our ordinance will amend the ordinance to say that the commission will pay for the interpreter. Hopefully the city council and the board of finance will approve the budget to pay for it. And that's what we'll do going forward. Because part of the question was, well, what if somebody brings in, you know, well, especially here we have a relatively large Spanish speaking and also Asian population. What if, you know, an adult comes in with their 12-year-old daughter and wants their 12-year-old daughter to interpret? I'm not completely comfortable with that. So I think this is a good way to go.
I think that's great. And also, I mean, the problem with kids interpreting or family members is, I mean, interpretation is a skill, and like the
Yeah.
telephone interpretation services, they've been trained to like listen, and they know, you know, the words for like housing related words that like another family member or kid may not know, legal words, things like that, and have like a duty of sort of neutrality to just strictly interpret one-to-one, you know, what's been said. You just if it helps at all. So the obligation to like provide interpretation actually comes from Title VI of the Civil Rights Act. And there's an executive order that is from the Clinton administration that talks about how anyone that gets federal funds, including towns, needs to do this assessment around language access and in pride, like some interpretation and translation. So if it helps with the budget request.
And so would you also, I guess, include in that, under that interpretation umbrella, sign language, hearing impaired people, right?
Yes, and that's probably going to come from like a different set of laws, like the ADA and Section 504 of the Rehabilitation Act. But I think, and there are similar services available for sign language interpretation too.
Looking behind you.
So I actually want to talk about two things before we finish. Our introduction. I mean, introduction is taking a while here. The first is in your materials, you'll see the list of towns with fair rent commissions presented in two ways. One is simply the mandatory and the non-mandatory commissions with an asterisk showing the ones that were added as a result of the 2022 statute. And you will see Torrington there in I guess in the fourth column is one of the new ones. And then it's the same commissions now, in the second slide, reorganized by area of the state. And so you can, if you look and see, so where's Torrington here?
Northwestern Connecticut.
Northwestern, all by itself.
Yeah, we're the only thing going.
All right, so there was a time that I believe Prospect had a fair rent commission 40 years ago, but it apparently died, and we tried to find records of it in their town ordinances, and we couldn't. The other thing I want to say, though, which I thought was in here, but I think may not be, is the issue of retaliation. And this is really, really important. And so I want to stress the importance of this, that nobody in their right mind is going to file a complaint with the commission if they think they're going to get evicted as a result of filing the complaint. So that both, obviously the tenant has an interest in not being retaliated against, but the town has an interest because the town, I mean, you are a town entity, a municipal entity, and you exist so that you can provide in a fair way relief in appropriate cases. If people feel they cannot complain to you, just as if they felt they couldn't complain to the code enforcement agency, that not only are they victims in that context, but you're a victim. The town of Torrington becomes a victim. So making sure that people are not retaliated against is really important. And that has come up in numerous ways because there are so many different ways that you can retaliate, and some of them are literally per se prohibited under the statutes. And all of them are within your jurisdiction. So I want to give you a couple of examples. Now, I do not know that everybody else who interprets the Fair Rent Commission statute is going to agree with me. And in fact, everything that Sarah and I have told you reflects our perspective and our opinion. So I don't want to tell you that somebody can't have a different opinion. But the first thing is there's a statute that is mentioned in the Fair Rent Commission Act, 47A-20, which is a landlord-tenant statute. And it says that you're protected against retaliation for 6 months automatically after certain trigger events occurs. And one of the trigger events is filing a complaint with the commission, and a second trigger event is the commission issuing an order. Those trigger a 6-month protection period, and the courts have ruled that's not based on motive. The statute refers to it as protection against retaliation, but the courts have said correctly that you don't have to prove retaliation because that's per se. So that means if someone files a complaint with you, they cannot be, say, evicted, for example, for 6 months, except for certain fault-based reasons, like if they don't pay any rent at all. That would be a ground for an eviction, but they cannot be evicted because their lease expired. And that's an automatic protection. So 6 months right off the bat. There is also a part of the Fair Rent Commission Act itself that says, with no time limit reference, that you cannot evict someone because, you cannot retaliate against someone because they filed a complaint with the commission. So there, it's a motive requirement. In other words, it's not, unlike that 6 months, which is an automatic protection, anything beyond the 6 months is going to have to go through a different statute, which is 7-148D, as in David. And there, the complainant, presumably the tenant, would have to show what the landlord's motive was. But there's no time limit. And this takes on significance because there are landlords who have actually openly said to the tenant, you filed a complaint with the Fair Rent Commission. Their decision is good for a year. You're going to be gone after a year because I will not renew your lease. Now, that's somebody announcing that they're going to discriminate against the tenant because they filed a complaint with the commission. The year goes by, the tenant comes back and says, my landlord won't offer me a new lease. That is within your jurisdiction to order the landlord that they must offer something to the tenant. If the landlord says, okay, fine, great, I'm going to raise the rent $600. Okay, that's fine. The tenant can file a complaint with the commission over the $600 rent increase, and you will get to decide whether that's fair or not fair. And you may be influenced to some extent by, it seems like it's retaliatory, but at least the tenant can get a hearing. And you say, well, 12 months, that's after our decision expired. Yes, but the statute says if the motive is the fact that they filed a complaint, then there is no time limit. So it's important for you to understand that you have the authority to protect people, not only during the immediate period, not only while things are pending, not only while it's being implemented, not only during the duration of whatever your order was for, whether a year or 6 months or a year and a half or whatever, but even at the end, But once you're past the 6 months, you're gonna need proof of motive. And you would hold a hearing on that. I mean, if the tenant would come back and say, I'm being discriminated against, you would do it just like it was any other Fair Rent Commission hearing, and ultimately, if it wasn't settled, you would hold the hearing and take the evidence and make your decision as to whether you felt they had or had not established the retaliation. So it's not like you don't get to think about it and consider the evidence that you have in front of you. So I stress that because I mean, we've had the landlord attorneys who have said month-to-month lease, that your order can only be for a month, and the landlord can evict the tenant after the month. Well, your order can be for more. That first of all, your order certainly can be and should be for more than a month, and second of all, the notion that you can evict at the end of the order assumes that it's not a retaliatory eviction. And people have said, well, how would we prove it at the end? The typical way you would prove it is you would find out, you'd ask, are other tenants in the building having their leases not renewed? Like, is the landlord clearing the building of all the tenants? If everybody's getting no renewal of leases, that sounds like it's not retaliatory. If they're the only one, and they're the only one who filed a complaint, and they're not getting their lease renewed, that's sort of suspicious. And again, I say it's important because you can't function as a commission effectively if people think they will successfully be able to retaliate against a person who complains to the commission. One of the other issues that came up, what if the tenant loses the case? The retaliation is for filing the complaint. The tenant isn't going to know when they file the complaint whether they're going to win or lose, nor will the landlord know. But the fact that the tenant might lose, unless it's not in good faith, there's a good faith requirement in the statute. But as long as the complaint was filed in good faith, then the retaliation piece is independent of who ultimately wins or ultimately loses. So, and especially with a lot of commission decisions being a compromise, it's hard to tell who, if you approve half of the rent increase, but not the other half, who won? Well, the tenant won because they didn't pay the full rent increase, but the tenant didn't want to pay any increase. So it's hard to label people as winners and losers under those circumstances.
So Rafi, one question I have is then, and first, I guess a comment, I would bet you there's few tenants who are aware of their rights relative to retaliation in the circumstance you're talking about. But do you think then that we should have in our, array of forms, a different complaint form? A complaint form based on retaliation?
Some commissions have different complaint forms. I think many of them have like I've seen many that have like a checkbox for like, is this about a rent increase? Is it about rental charges conditions? Is it about retaliation? And of course they could check more than one, and then a space to sort of describe what the issue is. Or there could be a separate one for retaliation. I think kind of whatever you all think would be most effective.
Well, I got a couple. Would you really want to use the word retaliation in your form?
Well, it is what it is.
It's the language from the statute, so.
Oh, okay.
You don't have to have a form for everything. I mean, most of the complaints you're going to get are going to be about rental charges.
Right.
So my feeling is, Sarah may not agree with me on this, but my feeling is it doesn't hurt to have that option in the form. I don't think that's the critical thing. To me, the most critical thing you need in a form, and I've said this to other people, is the empty space. That's to say, one of the questions in the form, whatever, use the form to get data, name, address, stuff about and all this basic stuff that would be helpful for you to have. But have an open-ended question, either at the very beginning of the form or at the end of the form. I think at the best at the beginning, actually. But why are you filing this complaint with us? Or what is it you're looking for? And with an open-ended, because tenants are unlikely to know what the Fair Rent Commission's powers are. And in some cases, they'll want a kind of relief that you can't give because it's not within, your authority. But finding out what it is that's causing this complaint will help you figure out how to deal with things. And
so to that last point you just made then, would it be appropriate if their complaint is such that we review the statute, and it does, basically, you know, from a litigation perspective, it doesn't state a claim upon which relief can be granted. Can we dismiss it outright, or do we always have to have a hearing?
I would say
Okay.
you don't always have to have a hearing, but to be careful because sometimes people do, I mean, at their core, there is an actionable issue that there is a concern about rental charges, but because of unfamiliarity, kind of lack of sophistication, they're not able to describe what's going on. So maybe interviewing them first, having, just checking it out. But I mean, there's some cases that are clearly going to be outside the jurisdiction. If, for example, it's someone who is looking to rent an apartment that they feel like the rent is unfair, they're not a tenant in place, that's clearly outside of the jurisdiction.
Sometimes, again, something that would fall into the category of where you just don't have jurisdiction at all. If you have a tenant who's in place and it feels like what they're complaining about is not something that the commission is going to be able to address, I would say you take the complaint anyway, just because it may get some conciliation. But I guess I would say you would, I think it'll be unusual where you'd have a situation where they would continue to be pursued to the hearing stage. But I would actually give it a hearing, even if it looked to you like there was no relief you could get.
That's the approach we've taken so far.
And I think a lot of those cases will either when it becomes clear, the tenant will withdraw the complaint if it's really that obvious, or there's probably a 50-50 chance that it'll settle. And effectively the conciliation will have solved the problem. It doesn't have to go to the commission hearing anyway, but you've actually worked out a problem that the parties couldn't work out on their own. So yeah, I think you're doing the right thing. Let me put it that way.
On this retaliation thing, when you brought up about the landlord retaliating against the tenant for filing a complaint, and then at the end of the lease, the landlord says, listen, you have to go. Tenant has the ability to say it's because of retaliation, because I filed the complaint. Well, what if the tenant during that time knows they can't get evicted, but becomes a nuisance tenant?
They could still be evicted for nuisance.
The issue basically arises with non-renewal of the lease. In other words, it's not a cause. I mean, even during that, let's just say you do a 12-month order and let's just say you've lowered the rent by $50. But the tenant engages in other breaches of the lease or nuisance behavior or anything like that. The landlord is not bound to wait till your order expires, in 12 months to bring an eviction based on the nuisance, because that's not retaliatory. I mean, I guess the tenant could try to, well, even under the statute, you're not going to be able to argue retaliation for that. So it doesn't affect evictions that are brought for a cause where you're showing some kind of a breach. But it will apply if you're bringing an expiration of the lease claim, which they call lapse of time. Your lease is expired and I'm not going to renew. So in that case, you're not disclosing something the tenant has done wrong. So that's the situation where the tenant would most likely have at least a reasonable claim of retaliation, that if it seems like they've been singled out because they had filed a complaint. I mean, that would be, that would be significant evidence. Let me put it this way, significant evidence of retaliatory motive.
And that gets hashed out in the eviction action.
Well,
right?
Yes, but from
Except for the non-renewal. The non-renewal, they could file a complaint with us.
Right. The non-renewal is something that you ought to be addressing. I mean, they could raise it in an eviction action also, but the problem with raising things in an eviction is that the consequence of losing an eviction is you lose the housing. If your goal is not to lose the housing and move, but to stay, then you don't want the issue to be resolved in an eviction. You'd like it to be resolved in a procedure where if you lose on the issue, you can just say, okay, fine, I've lost. I guess I have to, not I have to leave, but I'll have to abide by whatever the order is. It's the same thing with why you might file a complaint with the commission, and if you file it in good faith and if you lose, that doesn't mean you should be evicted. That just means you're gonna have to start paying the higher rent that you didn't want to pay. Well, but now you're gonna have to pay it. If you don't want to pay it, then you're putting yourself at risk of eviction because now the higher rent has gone into effect. And if you don't comply with it, then you're going to risk eviction for non-payment of rent. So it's from the point of view of the commission, I think you would like, if there's really a retaliation claim, you'd like it to be in front of you, where if the complainant loses on the issue, well, they're still there. They're going to have to, if, for example, let's just say the nuisance charge, the tenant claims that was a fake nuisance charge. They didn't do anything nuisance. It was an excuse to get rid of them. If you determine that, yes, that's true, then you're in a position to intervene and say you can't do that. But that would have to be, you would have to come to the conclusion that this was a fake charge. If it was a real charge, then they're not going to be protected against. That's not retaliation. If it's for something that they've done like that.
Do you have any questions you want to ask?
No,
Okay.
I have two completely separate questions, but did you want to go?
Well,
And we like questions. I want you to know, Sarah and I love questions. So any
Yeah.
questions you want to ask us, we're interested in trying to answer.
Well, the only thing I would have right now is there anything we need to vote on while we have the quorum?
I think we did.
What?
While we have, once he leaves, we won't have the quorum. So
He's
is there
talking
anything we
about
need to
Fari's
vote?
business On the agenda,
Yeah,
that's what he's
Just
talking
adjourning.
yeah, okay, so let's adjourn the meeting. While we have a quorum and continue.
I don't understand what you just said.
Once he leaves, we
Right.
can't vote on anything.
Right.
So is there anything we need to vote on now before he leaves?
My question is, do we have to vote on new commissioner and secretary? Because it's been a year.
No, the mayor appoints them.
Not
The mayor
secretary,
appoints.
not the
Oh,
secretary,
you mean officers?
Yeah,
yeah, officers.
Yeah, let's do that next meeting.
Yeah, we'll have to
okay,
do that.
I just
Yeah.
brought that up because that's something that.
Okay, then
Okay, then I have two questions.
let's officially close the meeting.
Yeah,
No, we're still in the meeting and
All
this
right,
is just part
all
of it.
right, then
And
let's,
it can go on forever.
all right,
Keep going.
thanks.
So we had one hearing, at least one, where the other side didn't show up. But we had the hearing, we heard from the tenant and, we thought it was too high, so we didn't. So we still went ahead with the hearing, even with one side, but instead of like in court where, maybe if there's one side, you don't even do it. Is
Right.
that?
Yeah, the landlord
Your
failed to
experience?
appear.
That's fine.
Yeah.
You can go ahead with the hearing and, determine if you think the tenant has like met their burden in showing that the increase or the charge is harsh and unconscionable. And as long as the landlord was given proper notice, you can just go ahead.
Do you think it's proper to draw a negative inference from the landlord's failure to appear? Just tossing that out there, yeah.
Well, they called it
I wouldn't.
the
I wouldn't-
argument.
I mean, there's certain things where, many of the factors are, would tend to weigh in favor of the landlord. For example, like the landlord has given up their opportunity to show that there's been an increase in costs. So, you need not consider the landlord's operating expenses. They chose not to, appear for the hearing.
I mean, I think that the tenant still has to prove their case. I mean, they have to convince you that this is not a fair, not a fair increase. And they still have to prove that even with the landlord not being there.
Which they did.
But I wouldn't, I guess I wouldn't go that last step and say that the landlord is admitting anything that the tenant says. I mean, you still have to decide you believe what the tenant is telling you. But the landlord is essentially waiving the opportunity to offer counter evidence. Now, sometimes the question is the flip side. What happens if the tenant doesn't show up? Well, the tenant's not going to be able to win.
Right.
And there the question becomes, do you reschedule the hearing? And I think most commissions, at least if this happens once, would reschedule on the assumption that probably there was some reason that the tenant didn't come. But if this happened multiple times, at some point, the commission's going to dismiss the complaint on the grounds that the tenant is not pursuing the complaint. But I think it's reasonable, as long as you know that the landlord got notice, I think it's reasonable to assume that if the landlord doesn't come, then they're not fighting the case, but the tenant still has to prove, to convince you that they're entitled, that they deserve, an adjustment to the rent.
I think the way we handled it in the decision was noting that the landlord failed to appear, but we did go through the 13 circumstances and made those fact findings.
I think that's right.
My next question is more in general. I was thinking, is the Fair Rent Commission, sort of how is it advertised? I mean, how do tenants know about it?
That's a great question, because I think tenants did not know about it until fairly recently, because many of them, even for towns and cities that have had them for decades, had essentially gone dormant. So, I mean, a choice, I think, for, Torrington is whether you want to advertise it, knowing that that will probably bring in a lot more complaints, because still
right.
we're in a situation where.
But we still have to weed them out to make sure that we match the
Sorry.
13 factors. The
That's-
13 factors, one of the 13 factors has to be addressed before we even take on the complaint.
No, I think we can assume that there are many tenants out there who probably have good reason to file a complaint,
But don't know about
And-
the commission.
but don't know
I
about
don't
it.
know what to do.
And once they know about it, we're gonna get whacked.
I think Bridgeport, I think, has a pamphlet they hand out. I don't know where they actually have it,
Yeah,
but I think it's Bridgeport that actually has a full page, a full-size pamphlet. What it is and explaining what happens.
And
And that's an
doing
excellent idea. I mean,
Yeah.
that the city of Torrington should be pulling some kind of, information that can be put out in places where and whatever the system the city is using to tell people about other services that are available in the city, whether, whatever it is, this ought to be routinely included as one of those services that gets covered. So you might have pamphlets that talk about multiple things that services provided by the city, and it ought to be in there. And it'd be good to have a separate pamphlet just for the commission.
I mean,
But
this
it's
is
true, though. I mean, the more you tell people about it, the more cases you're gonna get. So,
Thanks.
Thank you.
I mean,
Thanks,
some-
guys.
Oh. I mean, New Haven obviously has a lot more resources than probably any of our cities and towns, but they've started going to sort of community events and just including information about the Fair Rent Commission when they're presenting about other city services, which has resulted in like many more tenants know it's available. They do have a lot more complaints now, so that is, the thing to be prepared for, that the more outreach you do, the more likely it is that you'll get a lot more complaints. But you all been meeting for a year, so.
I think one of the other towns does something similar. I met at that latest conference, does something, it's their public relations department, or the person that runs the street fairs, the organizes all those things. She is actually kind of that point person there.
well, the city of Torrington doesn't have one of those.
But it goes along the lines of where they're putting that information out.
Until we get another lawyer in my office, I don't want any more complaints.
I know you don't. That's why I said you may not want to.
Okay,
Well, I have, there's a lot of, House bills going out in legislation. Is there any thoughts on what you like or don't like out there? Or you won't voice an opinion?
I think that's kind of beyond the scope of this training.
Well, no, because there are some that actually
We'll deal with the Fair Rent Commission.
Fair Rent Commission, an act establishing a cap on a fair rent, an act requiring the Fair Rent Commissions has to be balanced. There's another one here that says, enacted some maximum annual rent increase.
This one on security deposits.
We
No,
can,
just
we can
rental.
So-
testify
one
on
on
some of these, we
security.
could comment
Yeah,
on what the
enact
bills
the
Wait a minute,
do.
wait a minute, wait a
That's
minute.
helpful.
Go ahead. Go ahead,
So, I
Sarah.
mean, some of them are addressing, like, wouldn't actually do anything. So there's one, I can't remember the number, there's one that would require fair rent commissions to have open meetings, which are already required. There's another one to post bylaws, which, I mean, your bylaws, I know yours are already posted, and for, you know, they're a public record at any fair rent commission, so that's probably unnecessary. The one from the department, so the Department of Housing is actually the one that's proposed, basically a presumption that anything over 10% would be unfair in the first year after there's a new owner.
Yeah.
Unless there's been major renovations to the property. I think this is trying to address the situation. I don't know if it's happened in Torrington, but we've seen a bunch of places where out-of-state landlords come in and buy a property, immediately increase the rent. Sometimes they just double the rent without really doing renovations, which I think personally is interesting. Rafi, what are some of the other bills that I'm forgetting?
There's,
Operation and membership. Oh, I'm sorry. I got them here
Yeah.
in front. That's
yeah,
all.
no, there are probably about 10 bills pending that deal with fair rent commissions.
Yeah.
And I think the Housing Committee has been winnowing them down. Some, and as Sarah said, some of them are really like codifying things that people are probably doing anyway, or are supposed to be doing anyway. Some reflect hostility to fair rent commissions. And some, like the 10% proposal, are really directed not at your run-of-the-mill case, but, well, I don't know, maybe it's becoming run-of-the-mill, but about the problems that are arising from new ownership, where it's sort of a one, it's a presumption about the first year of ownership by a new owner. I don't know at this point which of those have the most life. Some of us, Sarah and I both monitor legislation and lobby on legislation. And I mean, I think we've taken the position that there's no need to put into the statute things that are already what commissions are supposed to do. There's some people who don't believe the commissions are doing those things and want to put it in. So if that's probably a toss-up in terms of impact on the commission. There's some things that are really designed to weaken commissions. There is a bill in there that would limit the commission's ability to protect tenants from retaliation to 6 months, which I think is a huge problem because it doesn't recognize that there are circumstances where the very deliberate retaliation comes after 6 months. So I think it reflects a misunderstanding of the existing statute. I think it's a good idea for you to monitor those things. I mean, you ought to know what's going on. If there are public hearings up there, and there's nothing that says you cannot testify at a public hearing. I mean, that would be your own. I mean, maybe that's something you'd have to be running past, the city government as to whether it's okay or not okay. But now there is also something fairly new that is called the Connecticut Fair Rent Commissions Network, which has been organized out of New Haven. And you should have gotten a notice about this, because I believe
Kevin and I went to the meeting in
Okay.
Hartford, yeah.
Yeah, and that at this point, that entity is not really taking positions on anything, but they are supposed to be monitoring. But I don't know that, I mean, the creation of the ability to monitor is really just getting off the ground. Meanwhile, the legislature is moving very fast. So I don't know to what extent they've been able to actually circulate any monitoring. But that actually, if that's functioning, and it may not really be functioning until next year, if that's functioning, that would allow you to get yourself on sort of a list, statewide list, where someone would systematically be watching what's filed in the legislature, and we'd be sending it out to all the fair rent commissions so that they could look at it, and if there was something they wanted to convey, they could. Right now, you probably still have to do it on your own.
Okay.
One more quick question.
Let's wrap it up. Go ahead.
You're, Ralph, you're the attorney for Connecticut Legal Services. What is that and what do you provide?
I can answer that question. Go ahead, Rafi, though.
Well, Connecticut Legal Service, there are 3 legal aid entities, all nonprofits, that among them sort of divide up the state of Connecticut. There's one that's mainly called Greater Hartford Legal Aid, that's mainly Greater Hartford area. There's one called the New Haven Legal Assistance Association, which is the Greater New Haven area. And then there's a third one called Connecticut Legal Services, which covers the rest of the state. And so they represent people who are very low income. The basic standard is 125% of poverty. They represent them in civil legal matters as distinct from criminal. So if you're very low income, you may be eligible for a public defender in a criminal case. And the public defender is a state employee. That the public defender agency is within state government. The legal aid programs are nonprofits, private nonprofits. So I work for one of those 3 programs, and that program is Connecticut Legal Services. And to a limited extent, they may on occasion represent people at Fair Rent Commission hearings. They may also advise people because they get way more requests for help than they can possibly, they don't have enough lawyers for everybody. And
There used to be a legal services office in Torrington, and I, in fact, was a work study student for them many years ago. I think, Rafi, when I saw you, I introduced myself and
that's right.
mentioned Bob Wenton and Ron Rosenstein, David Snyder. So at one point, Torrington had a legal services office that had 3 attorneys and 2 paralegals. And now we have none.
Now you have none. Connecticut Legal Services, over the years, offices were closed. Some of the outlying offices were closed. Torrington is handled through the Waterbury
Right.
office of Connecticut Legal Services. So Torrington is still within the coverage area, but the legal aid programs are all very strapped in their ability to take cases, and they all triage in various ways. In the housing area, they tend to triage very much towards eviction defense, which doesn't help people, like with a fair rent complaint, where the whole point is not to have this resolved in an eviction case, but to try and get it resolved in a way that doesn't that doesn't put the tenant's tenancy at risk, as long as they follow whatever decision you make. And but the answer is Connecticut Legal Services is the legal aid agency that would, if somebody is going to handle litigation for them, would be doing it for Torrington, because you're in their service area, basically.
And I'll just explain I'll just explain what the Connecticut Fair Housing Center does too. We're also like a specialty sort of legal aid program, a nonprofit law firm, and we do housing discrimination cases. Usually that's like investigation and affirmative litigation, sometimes eviction defense, sometimes representing people in fair rent commissions when there's housing discrimination at play as well. Or if it's a bunch of tenants who are all like facing the similar situation and going to the Fair Rent Commission kind of together. And then we also do foreclosure defense and issues involving homeowners as well, which I know is not, what the Fair Rent Commission is going to handle, but just, so people know if it comes up and, other things in your life.
So there is a possibility for a tenant to seek legal aid and maybe even just guide them through the process.
It's
Yeah,
very limited, but yes.
Yeah, it's possible, but quite frankly, it's unlikely.
Right.
Yeah.
And that's, I mean, partly it's less likely in Torrington than in Waterbury, because it's a trip just to get to the legal aid office. But the other thing is, legal aid is limited in what kind of walk-ins it takes. There's actually an application process that filters out who's gonna get to talk to anybody in the legal aid office, but based on what's the nature of the problem. They may be able to give some basic advice over the phone, but in terms of actual representation, it's going to be unusual, quite unusual that that the tenant is going to. It's unusual the tenant would show up for your hearings with a lawyer. It's much more likely that the landlord would show up with a lawyer, but it's also certainly not uncommon that neither side has a lawyer. I don't know what your experience has been about attorneys, but most of the time when an attorney's there, it's an attorney for the landlord,
Right.
and not for the tenant. And that actually puts, I mean, that takes you to the question of how much informality you can have, because part of what you need to do is you need to hear both sides. And presumably, if a party has a lawyer, they know how to present their evidence. And that's what someone is basically expects when you have a lawyer. When the party's there, and it could be the landlord, not just the tenant, when the party's there without a lawyer, they very often do not know or understand what is relevant and what you need to hear. And I think it's important that you as a commission take the approach that if you need to ask them questions to find out from them the information that's going to be relevant to you in making your decisions, you should ask. I mean, they're there as a witness. So if they don't, for example, it's perfectly legitimate if a landlord doesn't say anything about his costs in running the building, for you to say, can you tell us anything about your costs? Now, if his answer is something that's really undocumented, well, I think I'm losing money or something, but no evidence more specific, you may not want to give much weight to that. But if he didn't know that that was relevant, then I don't think it's inappropriate for you to ask the question. The same is for the tenant. I mean, it's perfectly legitimate for you to say to a tenant, if you had any problems with getting things repaired in your building, even if the tenant didn't bring it up themselves, because the tenant's answer to the question may influence how you weigh the factors and decide the case. So, I mean, you have to use your judgment on how much you want to do. But I think especially when you're dealing with people without lawyers, and they're physically present, or it's in a Zoom meeting and they're in the meeting, I think you should sort of give the benefit of the doubt to the fact they may have unintentionally failed to present something that you think is very important for your thought process in making a decision, and ask them about it. You may or may not get useful information from that, but that's part of the reason that you need to maintain a kind of a level of flexibility. That, I mean, you can't have a free-for-all. It's got to be an organized meeting, and I assume you've run these meetings in that way. But you also need to, particularly for people without lawyers, you need to make sure that they've had a chance to tell you the information you needed. Just as sometimes they may want to go on at length for something that is completely irrelevant, and at some point you might have to stop them. But
That answered my next question.
but you know what's relevant better than they know what's relevant. Let me put it that way. But you have to also be careful not to jump to a conclusion that something's irrelevant without being pretty confident that it really is. Because sometimes things find their way in. It takes people a while to get around to telling you something that you think is actually important. Well, all I can say is that every case is different. And how many cases have you actually had that have gone to a hearing?
No, more than that.
I've written it, three.
Yeah, I want to say like 11.
Well, cases, but how many actually came to hearing?
Yeah, so we didn't have hearings.
Yeah, how many hearings? I think we only had
Say
like
at
4
least.
hearings. We had 11.
Well, we can't agree on how many we've had.
Well, all right, let me ask, how many complaints have you received?
At least 11 or 12.
So it's like you've gotten roughly 11 complaints, and you've held roughly 4 hearings.
4 or 5,
Yeah.
maybe, yeah.
I don't know how many-
Right. So a little less than half of the complaints have resulted in hearings.
Yeah,
Yeah.
and the other ones, we didn't have hearings because, of course, I'm the contact person, I'm the staff person. and speaking to the landlord and the tenant, and the notices we send out to them, we encourage them to talk and try to work it out. And so those other times they've called and said, okay, we worked it out, we don't need a hearing, which is great.
Which is great. Yeah, I mean, and that's that. I cannot emphasize enough how important the function that is of commissions, even though that's not in the statute anywhere. Nowhere does it say your job is mediation, but it really turns out that way. And in the same way that in eviction cases, there's no mandate for mediation in eviction cases, but the court system has determined that it is prepared. I mean, there is provision in the Housing Court Act for mediators, but the court system has decided that they want the cases to go through mediators before they get to the judge, and so mediation in that system is pretty much mandatory. And once you're in an eviction, they're going to send you there because they have such a high rate of settlement. As I say, perhaps too high a rate of settlement, but it's significant. So yeah, so this is good. I mean, what you're saying sounds pretty normal. That would kind of reflect what I would expect.
Mhm. Okay,
Alright,
okay,
I'm happy.
I'm ready to go home.
Thank you.
Well,
Thank you.
thank you for your time and helping us out quite a bit.
Yeah, well, thank you for inviting us.
Yeah, thank you
I
so
think that,
much.
Yeah, thank you, Sarah. Thanks, Rafi.
Can we write you with questions if things come up later, or?
sure, we love, I told you, we love to
You
answer
like
people's
questions?
All right, thanks.
Okay,
Okay,
thank you.
so I
Yeah.
think we'll
Have a
end the
great
meeting.
night.
Yeah, thank you
good
both
evening.
very much. Bye-bye. I guess I gotta figure out.
Okay.